Today's Municipal Liability series, our discussion continues. In our legal segment, we're going to touch on the issue of violence in schools, whether it be in public or private school. Here to break down this issue and explain your legal rights is our legal correspondent and attorney, David Lesch. And David, good to have you back.
Out of all the cases that I see in my office involving municipal liability, whether it's subways or whether it's buses, you're really talking about an area that is growing, and that's violence in schools. And it's not necessarily just student-on-student violence. It could be student-on-teacher violence. It could be teacher-on-student violence. And when the parents, especially when the parents come into my office, when their child has been assaulted either by a student or many times by a teacher, they think it's just a given that it's a successful type of case, but it's not. And the reason for that is when you have an incident in a school involving a child, you can really only hold, if it's public schools, the Board of Education, or the private school responsible, if the school knew or should have known that there was a propensity for violence with respect to the child who initiated the contact. What that means is, if it's just a spontaneous act, and one student decides just to hit another student in a lunchroom or someplace else, and the school did not have any knowledge or didn't know that this particular student was a troubled student, then you're not going to be successful, and it's tough for me to tell parents that. But however, if it's a situation where where the school knew or should have known that there was a troubled child or a troubled teacher, that would be different. I'll give you an example. I had a case came into my office with two young women from the Dominican Republic, came into the United States, came into school, did not speak any English, and were starting to get bullied very quickly. And they didn't want to go to school. And I think somehow the dean got wind of this, and the dean called them into the office and said, look, I understand that you don't want to come to school tomorrow. We've been told this, but you have to come to school. That's the way it works here in New York. You don't have a choice. But don't worry, we'll protect you. We're going to have the bully put into detention. You'll be fine, but you have to come to school. You have no choice. Well, what happens? The next day they come to school. The bully leaves detention and single-handedly puts both of these girls in the hospital for 2 weeks. Now, that was a case where I was able to maintain an action against the Board of Education, because not only did they know that this girl was dangerous and had committed other violent acts in the school, but they also had promised the students, we're going to protect you. So there's an issue of what's called reliance. You're relying on the school. So that case was a little bit easier for me to be able to bring to trial. I was able to settle it once we picked the jury. But where you have a case where a student just decides out of the blue to hit another student in the face or to do some other type of damage, much more difficult. I have to get the school records. I have to see whether this student has had any kind of history. And the Board of Education always fights me to see if I can, when I want to get these school records, to see, is there anything in there that will tell me whether this child has had problems in the past and the school knew about it and didn't tell the parents, either the bad child's parents or the person who was assaulted, their parents. So it's always a fight for me. Second problem, it's not just whether or not you're injured, it's where you're injured. Well, you say, what do you mean? Well, a lot of these fights happen outside of school premises. As you probably remember as a kid, what do they always say? Well, see you after school.
After school.
We'll see you after school. It could be a block away from school. It could be a couple of blocks away. If the school knows that this fight is going to take place, or knows that fights do take place within a block or two from the premises, they can still be held responsible. So it's very important for teachers to know this, especially if it's an after-school program, which happens all the time. Sometimes you have these after-school programs come in to monitor or to take over. It could be basketball, it could be volleyball or something else. So the Board of Education doesn't necessarily have anything to do with it, because it's the after-school program that's responsible for it, and that's where the violence takes place. But if the Board of Education knew or should have known that during these after-school programs there's a violent act, or there have been violent acts in the past, you can hold them responsible. So.
Questions that you should be asking if you're a parent.
Well, I was about to get to. That's very important. What should you do as a parent to make sure that your child is protected? That's the most important thing. First of all, look for the telltale signs in your child. A lot of times they'll be withdrawn. They won't tell you. They'll be embarrassed. If you see a bruise, they're turning away. They don't want to go to school. That's a good indication that they're being bullied. So it's very important that if this happens, you go right to the school and you tell the school so they write this down, because you need a paper trail. Because it's only from that point that I could use this and use this to show, well, look, the school knew or should have known. That's the first thing. The second thing is you have to document it in terms of medical treatment. Get them to a hospital. Get them to a psychiatrist or a psychologist, so at least I can show that it's in the record that they're getting some kind of medical treatment. That's very important. The third thing is the safety transfer. You may want to get the school to let them know that you want to get out of there. You put your papers in quickly because it's such a slow go from the minute you want a safety transfer. That you have to show that your child's been in imminent harm, that there's been any type of violent act. So you got to get these papers in. So these are three things that are very, very important. And don't be afraid or embarrassed to tell your child, look, tell me what's happening in school. Your grades are going down. What is going on here? What's happening? Somebody bothering you? Is a teacher bothering you? Because teachers assault kids as well. I have a couple of those cases, unfortunately. And I've had teachers who've been attacked by students. So all these things happen within school grounds. You just have to make sure that you get your child to tell you what's happening. You can't be an absentee parent. I tell that to viewers all the time. If you're not involved, your child's not going to tell you.
Are we seeing a lot of these cases coming through the court system?
Look, I see. It's always a pattern, and I tell you this, Darren, that there are patterns where cases go up, cases go down. Lead paint, for instance, on the decline. Maybe mold and mildew cases on the decline. Violence in schools on the uptick. I see that. These are the kind of cases that I end up in court on. These are the kind of juries that I pick. So I can see that this is on the rise. So what does that mean? It means that the schools are festering an atmosphere that's leading to violence. So although they're talking about bullying now and how that they're putting away, you see that on television now.
Right.
We're trying to make sure that there's no more bullying. Students are bigger, they're tougher, their parents aren't home as often, they're working. I don't know, when we were children, a lot of times you had a parent who was home at least.
Was home.
You don't have that anymore. So they're growing up much quicker.
So really, these cases are not frivolous and non-merit?
No, they're real. When a kid comes home and he's got bruises on his body because somebody else did this to him, it's real. The problem is being able to prove the vicious propensity, that it's not a spontaneous act. These are all legal terms, or tough things to do, and that's that's the job of the attorney. But it's easier for us to do that if you set it up early enough so that when the time comes that you walk into an attorney's office and you say, my child was injured, I want to make sure that the school's punished. Well, I can say, well, did you complain about this? In writing, certified mail. Did somebody give you any records? Make sure that you take the position that you're going to set this up to protect your child, so that in the event you do come in to see me or somebody else, that you have all your ducks in order. And by the way, the most important thing is, we can always get this out here, you have 90 days to file a claim against the City of New York, including the Board of Education, 90 days. Private isn't the same way. Private school, you don't have to do a notice of claim sometimes. But with the City of New York, and it's a school, whether it's a subway, municipal liability, you got your 90 days. So 90 days from the date of the incident, very, very important.
All righty, David Lesch, thank you so much for
my pleasure.
Giving us some information. As always, you can catch him on Bronx Legal, find out all the latest information and what's coming up on Bronx Legal soon.
Bronx Legal, we have we have an immigration segment that's going to be coming up in about a month, and we have a couple of landlord-tenant tips. We're going to be giving some good information in the next 3 to 4 months.
All righty, Bronx Legal, make sure you check it out with David Lesch.